Hey everyone, and welcome. Today we're diving into the fascinating and sometimes tricky world where medical practice meets legal responsibility right here in India. It's a relationship that touches every single one of us, right? Whether you're a doctor, a patient, or just looking out for your family. So let's get into it.
It's a huge question, isn't it? What happens when a split-second decision in an operating room could end up as evidence in a courtroom? What are the ground rules? What are your rights as a patient? And what are a doctor's duties? That's exactly what we're going to break down today. Okay, so first things first, everything, and I mean everything, starts with that unique bond between a doctor and their patient. It's way more than just a quick chat about your symptoms. It's a foundation built on trust, on skill, and on a promise that's deeply understood even if it's never spoken out loud. You know, you don't usually sign a formal contract when you see a doctor, do you? But in the eyes of the law, that visit creates what's called an implied contract. What that really means is a legally binding relationship kicks in the second a doctor agrees to treat you. And from that moment on, they have a legal duty to give you a reasonable standard of care.
And this idea goes way, way back. We're talking about the Hippocratic Oath. This part of that ancient pledge is the absolute cornerstone of patient confidentiality, or what's also called professional secrecy. It's a moral promise, for sure, but as we're about to see, it has some serious legal teeth. It's the guarantee that your most private details stay private.
And believe me, the consequences for breaking that trust can be huge. Just look at this classic case. A doctor spilled a secret about his patient's pregnancy, and it completely upended her life. So she sued him, and the court awarded her what was, at the time, a massive amount of money. This case set a powerful precedent. Breaking a patient's confidence isn't just unethical, it can hit you hard in the wallet.
But what happens when things go beyond just breaking a confidence? When a doctor's actions aren't just a simple mistake, but a serious betrayal of their professional duties? Well, this is where we get into the really serious territory of professional misconduct.
Now, here's the crucial part. Who actually gets to decide what counts as misconduct? It's not just about what the public might find shocking. The real test is whether a doctor's own peers, other doctors who know the standards and ethics of the job inside and out, would consider their actions disgraceful. That's who makes the call.
And the consequences, wow, they are serious. They can range from a formal warning all the way up to getting temporarily suspended. But the ultimate punishment is something called pineal erasure. That's when your name is literally struck off the medical register. The source material calls it the professional death sentence because, well, it completely ends your career as a doctor.
To kind of wrap our heads around this, the medical community often uses a handy, if a bit grim, way of remembering the big ones, the 6 A's. This mnemonic covers some of the most serious no-nos, from associating with unqualified people, quacks, to being under the influence of alcohol or drugs while on the job. Okay, so we've talked a lot about the doctor side of things. Let's flip the script. Let's talk about your power as the patient. What happens when you're the one who gets hurt? What can you do to seek justice?
This is a super important legal idea to get. See, negligence isn't about guaranteeing a perfect cure. Medicine isn't always exact. It's about a doctor failing to provide a reasonable standard of care, the kind of care any ordinary, competent doctor would have provided in that same situation. And critically, that failure has to be the direct cause of harm.
And to make this crystal clear, we're not talking about small judgment calls here. Look at these examples. Leaving a surgical tool inside a patient, operating on the wrong knee, giving someone the wrong blood type, these are what you call stark, undeniable failures of care. They're the kind of clear-cut cases where negligence is pretty obvious. So, if something like that happens, what can you do? Well, you have a really powerful shield. The Consumer Protection Act, or COPRA, was a total game changer. The Supreme Court confirmed that this law applies to medical services. What this does is it reframes the whole relationship. You, the patient, are a consumer, and medical care is a deficient service. This gives you a direct, much more accessible path to fight for compensation. And this act gives you these 6 fundamental rights. It's like a patient's Bill of Rights. It covers everything from your right to be safe and informed to, most importantly, your right to seek redressal. Basically, to get things made right when they go wrong. It's a system designed to empower you. Now, this is a distinction you absolutely need to get. Not all negligence is treated the same way by the law. Most cases are civil. That's where a patient sues a doctor for money to compensate for their injury. But then there's criminal negligence. This is much, much rarer and way more serious. For a case to be criminal, you have to prove the doctor's actions were so incredibly reckless that they showed a complete and total disregard for human life. And that brings us to, well, the biggest questions of all. We're moving into the most profound and challenging area where medicine and law meet. Those moments hanging between life and death, where the legal and ethical questions become incredibly intense.
Euthanasia. You've probably heard it called mercy killing. It forces us all to really confront our deepest beliefs about life, about suffering, and about a person's right to choose. It is, without a doubt, one of the most fiercely debated topics in medicine and law, not just in India, but all over the world.
The difference here is absolutely vital, both legally and ethically. Think of it like this. Active euthanasia is an act of commission. It means taking a direct action, like giving a lethal injection to cause death. Passive euthanasia is an act of omission. It's about stepping back, maybe by removing a ventilator, and allowing the person's underlying illness to run its natural course. That distinction is at the very heart of the legal debate.
So, when a death seems suspicious or isn't from clear natural causes, the legal system has to step in. And a key player here is someone called the coroner. Now, a coroner's job isn't to punish anyone. Their one and only duty is to investigate and hold an inquiry to figure out the facts of what happened.
And it's so important to understand that a coroner's court and a regular magistrate's court are two totally different beasts. A coroner's court is a court of inquiry. Its only question is what happened here. In sharp contrast, a magistrate's court is a court of trial. Its job is to answer the question, is this person guilty? That basic difference changes everything about how they operate.
And all of this leaves us with a huge, critical question for our time. Modern medicine is incredible. It can keep a human body going long after any real quality of life is gone. And this presents us with a profound challenge. How do we make sure our laws, our ethics, keep up? How do they evolve to handle these new realities with dignity, with compassion, and with justice? It's a question that, sooner or later, we're all going to have to think about.